In Virginia, a product can be sold legally one day and seized by law enforcement the next, even if nothing about the product itself has changed. THCA flower is one of the clearest examples of how confusing Virginia cannabis law has become. Today, we are breaking down what THCA flower is, how Virginia law treats it, and why legality on paper does not always mean safety in practice. Here's the context and background. Over the past few years, Virginia has become a patchwork of cannabis-related laws, regulatory gaps, and enforcement discretion. While adult-use cannabis legalization stalled at the retail level, alternative products like hemp-derived cannabinoids expanded rapidly. THCA flower entered the market through federal hemp definitions under the 2018 Farm Bill. Under federal law, hemp is defined as cannabis containing less than 0.3% delta-9 THC by dry weight. THCA itself is not delta-9 THC. However, when heated, THCA converts into delta-9 THC. This chemical reality is where Virginia compliance becomes complicated. Here's the legal explanation. Virginia law does not regulate cannabis only by chemical labels. It also considers intent, form, and effect. Under Virginia Code, marijuana is broadly defined as cannabis containing THC, regardless of how that THC is produced or activated. Here is the key compliance issue. THCA flower is visually, structurally, and functionally identical to marijuana flower. When combusted, it produces delta-9 THC. Law enforcement and prosecutors do not need to prove how the THC formed, only that THC is present. Virginia does not currently provide a statutory exemption that clearly protects THCA flower once it is combusted or possessed for consumption. In practice, this means legality depends on interpretation, testing methods, and enforcement discretion. That is not legal certainty. That is regulatory risk. Federal law versus Virginia law. Many sellers rely on federal hemp language as a shield. However, federal legality does not override state enforcement. Virginia has the authority to define controlled substances more narrowly or more broadly than federal hemp definitions. Virginia courts have historically deferred to substance effect rather than pre-use chemical status. If a substance produces intoxication consistent with marijuana, it may be treated as marijuana under Virginia law, regardless of labeling. This disconnect is where many consumers, retailers, and even landlords get caught off guard. Who this affects? This issue does not only affect consumers. It affects small business owners operating hemp stores. It affects delivery drivers. It affects landlords leasing retail space. It affects medical cannabis patients who assume all cannabis-like products fall under the same protections. It also affects local governments like Norfolk, where zoning, nuisance enforcement, and business licensing can be impacted even without criminal charges. Civil enforcement often happens quietly and without headlines. Here's a realistic scenario. Imagine a Norfolk resident legally purchasing THCA flower from a storefront operating under hemp compliance claims. The product passes lab testing for delta-9 THC at rest. The consumer transports it in its original packaging. During a traffic stop, law enforcement identifies the substance as cannabis flower. A field test indicates THC presence. At that point, the burden shifts away from the label and toward the substance itself. Even if charges are later dismissed, the legal exposure, confiscation, and stress already occurred. That is the reality gap between legality and enforcement. Why this matters? Virginia cannabis law is not only about what is written. It is about how laws are enforced on the ground. THCA flower sits in a legal gray zone that creates unequal outcomes based on geography, officer discretion, and prosecutorial priorities. This uncertainty undermines public trust and exposes compliant individuals to unnecessary risk. For policymakers, it highlights the consequences of partial legalization without regulatory clarity. For the public, it reinforces the need for education rather than assumptions. What to watch next? Virginia legislators continue to debate hemp regulation, intoxicating cannabinoids, and enforcement authority. Future changes may include explicit bans, licensing requirements, or reclassification. Until then, ambiguity remains the rule, not the exception. Staying informed is not optional. It is essential. Question. Do you believe Virginia should clearly regulate THCA flower, ban it outright, or formally protect it under hemp law? Put your answer in the comments and explain why. Before we close, it is important to explain why engagement on videos like this actually matters. Virginia cannabis law is still developing, and much of the public conversation is driven by misinformation, headlines, or assumptions that do not reflect how the law is enforced in real life. When viewers like and comment on educational content, it signals to the platform that factual, policy-focused discussions are valuable and worth sharing. Subscribing helps ensure that more people receive updates when laws change, regulations shift, or enforcement practices evolve. These topics are often complex, and staying informed over time is more effective than relying on one-off information. Commenting also matters because it creates a public record of questions, concerns, and perspectives from people who are directly affected by Virginia cannabis policy. Those discussions help highlight where confusion exists and where clearer regulation may be needed. If your goal is to understand the law as it actually functions, not just how it is described, supporting educational content helps keep these conversations visible and accessible. Please like, comment, and subscribe for more videos like this.